quick question. Is that I've heard a lot of people this story, from a lot of different people, and you both can answer this question if you like. That when they go into the courtroom, they're facing some type of criminal charge, and when they go in and speak with the public defender will say to them that if they plead guilty, that they'll get a lesser charge or whatever. Do you think that that's ethical? And if you were to find out about something, what kind of disciplinary action would you take against those that are saying that instead of versus the client telling the truth to the judge about what happened?
Well, as a criminal defense attorney, you've got several responsibilities to your client. One is to make sure that you have all the discovery and the evidence against your client, to make sure that the prosecutor is able to establish a case against your client. That's your first obligation before you even discuss, a plea bargain or a settlement of the charges. The other thing, you have an obligation to your client to kind of predict to them what may happen if they take it to trial. And that's something that's very difficult to do. You have to explain to them if there's any type of mandatory sentence for that particular charge, or what the likelihood of what happened if they do go to trial, what the expectation would be if they're found guilty. So, when you're talking, I understand where you're coming from, is you maybe feel that a lot of criminal defense attorneys twist their clients' arms. There are perhaps attorneys that do that, but most of the time, most defendants, to be honest with you, are looking, okay, what gets me out of jail?
Well, mostly I'm talking about the public defenders. I'm not talking about people that could afford an attorney.
Right.
I'm talking about people that are going into the courtroom and they don't have the money and they're appointed a public defender.
Right.
And a lot of times,
Right. And our system statewide is pretty much broken in the sense that we don't have enough public defenders, and their caseloads are extremely high. In our court, we don't utilize the public defender's office. We contract with private attorneys to come and do our public defender work for those that can't afford attorneys. But they're under obligation to weigh or to judge the merits of the prosecutor's case. If there's a problem with the case, I think they're under obligation to defend their client to their best ability. So, but as for a judge, I haven't really seen that, before me, where I felt like a public defender was just, just caving on the case, based on, because you don't really get to see what happened, or you don't get to see the facts of the case until you go to trial. So, but our public defenders, if they feel that they have a good case, they take those cases to trial. Okay. So.
Well, before we end, we just found out that one individual is supposed to have gotten 40 years behind bars for shooting.
Yeah, that same DA did a plea agreement and sentenced with 40 years for attempted murder. So I don't understand how that DA could look at 2 years for attempted murder on a police officer and 40 years on a rival gang member.
Well, we just hope that any prosecutor and district attorney that pleads anybody out for attempting to kill a police officer, hope they never run for judge. And with that, we want to thank you, gentlemen, for being here. Thank you so much
for this opportunity.